My name is Christina Early. I'm the Democrats of Greater Tucson's board secretary, and I've taken over the salons for a couple of months here while our program director, Mike Bryan, is off doing some political things that he wants to do. So we'll go ahead and get started. We've got a great lineup this evening, and just real quick, we'll do a little bit of housekeeping here. We're going to have our speakers speak, and then you'll be able to ask your questions to the speakers via chat. Joe and Susie are going to be watching the chat, and we will get those questions answered throughout the evening. And also, please, everybody keep muted. This will allow our speakers to be heard, and we won't disturb other folks that are trying to listen this evening. So let me introduce our first speaker, Miss Dianne Post. She's a staunch activist, author, and attorney, and she's going to be talking with us about the ERA and the impact that that has on our women's rights. So Dianne, thank you so much for being here, and the floor is yours.
Well, thank you very much for asking me. And I am an attorney, and I am the chair of the Equal Rights Amendment Task Force here in Arizona. So the first thing I'm going to talk about is the status of the ERA, and then the impact it's going to have or can have on reproductive rights, and then trying not to get in Kris's mess, but I'm going to talk just a brief overview about what laws are in effect in Arizona regarding this, because there's such misinformation out there. So to begin with, you've seen the language of the ERA. It's on that invitation. So that's it. That's the ERA. So it is the 28th Amendment. It is passed according to Article 5 of the Constitution. 2/3 of the Congress sent it out to the states. That happened. And 3/4 of the states ratified it. That happened. It's passed. It is the 28th Amendment. Now, does everyone agree with me on that? Of course not. But that is not unusual, and that was expected. Every single amendment that has expanded constitutional rights to vulnerable groups has been attacked. 13, 14, 15, 19, everyone has been attacked. So we expected that it would be attacked. We're not surprised at all by this attack. So it's there, but it is, of course, under attack. It took 2 years then to go into effect, and it actually went into effect January 27, 2022. And lawsuits have started to be filed under it. So 2 things are going on about that, one in the court and one in the Congress. What's happening in Congress is that the House has passed twice now a bill that says, forget the timeline, there's no such thing, it was in the preface, we eliminate it, it's gone. So they've passed that twice, and all Arizona Democratic members have voted for it. So it is now HJ Res 17, and it's in the Senate. So we need pressure on Schumer, bring it to a vote, bring it to the floor. So that's one action you can take out of tonight, is an email to Schumer telling him put HJ Res 17 on the floor for a vote. Secondly, the Senate has a companion bill, which is exactly the same, which is SJ Res 1. That's stuck in the Judiciary Committee in the Senate. Nadler's ahead of that. So we need to get it out of the Judiciary Committee, paste it on the floor. But we don't need to if you would just put HJ Res 17 from the House on the floor. So that is the action that you can take, and that's what's happening in the House. The other thing that's happened in the House is that the House has passed 891, HJ Res 891, which says, thank you, ERA, you're here, we welcome you, yay, yay. Now, this is not necessary for an amendment to be in the Constitution, but it has happened before, when Congress, after it became a part of the Constitution, sent out resolutions saying, yay, yay, here we are, welcome everybody. So the House, again, has passed that. It's over at the Senate. We need the Senate to pass it. And again, all of the Arizona Democratic delegation is on it, and in the Senate, both senators are on that bill. So that is going on. That's what's happening in the congressional arena. In the legal arena, in the courts, 2 lawsuits have been filed. One was filed in Massachusetts before the ERA was even in effect. And they lost in the district court, tried to leapfrog to the Supreme Court, which said no thanks and sent them back. So they're down there doing whatever they're doing. That's probably not going to be the decisive case. The decisive case is going to be the one filed by the 3 attorneys general of the last 3 states that ratified the ERA, which is Nevada, Illinois, West Virginia. After West Virginia turned back to Republicans after this last election, they pulled out from that lawsuit, which we expected they would. But it doesn't change the lawsuit. It's now Illinois versus Fierro versus West Virginia versus Fierro. Now it's Illinois versus Fierro. Fierro's gone too, but it doesn't matter. It is the archivist to whom it is against. So it's still there. Now that they lost at the district court level as well, and it's at the appeals court level, the DC appeals court, to be heard on September 28th. Oral argument will be September 28th. Now the issue there is that under the previous administration, Bill Barr put a memo into that lawsuit opposed to the ERA. Prior to that, the Department of Justice memo, which was from the Carter era, was in favor of the ERA. So Barr pulled that, put in a new memo, which is complete nonsense and is opposed to the ERA. So of course, when Biden got in, then the lawyers, we asked him, get rid of that DOJ memo and put in a new one. Well, it took a while. Merrick Garland has been a huge disappointment to me and many other people. But anyway, we got enough pressure that they pulled the memo and they put in another one, but it is not what we wanted. It's a different memo. It says we support the ERA, but our position is that they don't have standing because the courts have nothing to say about this. The administration has nothing to say about that. It's absolutely true. The administration has nothing to say about that. They have no role in an amendment. So they're saying the courts have no role in this. It's only Congress. So dismiss the lawsuit and just let Congress decide the ERA is in or not. Well, the unintentional, well, maybe it was intentional, we don't know. A possible benefit of that is we don't want this case to go to the Supreme Court. Do we want this case to go to this nutcase Supreme Court? No, these people are completely rogue and completely out of their minds. So I know what would happen, or we all think we know what happened if it did go to the Supreme Court. So the DOJ position now in this lawsuit is it has to just be Congress. So that's why there's focus on Congress to say, no, there is no deadline. Hey, yes, welcome, blah, 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 we're here. So that's what's going on in the legal arena for the ERA. It's in place, but it's challenged as expected. And there are issues going on and legal issues in court and legislative issues in the Senate and House. All right, next, what impact will the ERA have on reproductive rights? The impact it will have is changing the standard of review. When a Supreme Court case, when any case of discrimination is decided, the courts have to look at one of 3 levels of analysis. The 3 levels of analysis are rational relation, intermediate scrutiny, and strict scrutiny. The lowest level rational relation, you almost always lose. The highest level strict scrutiny, you almost always win. So I'm going to explain these as well as I can and give you an example of each. Rational relation, all the court has to do is say there is some possible relation between what the law was that the legislature passed and what impact or what problem they were trying to deal with. We don't care if it really deals with the problem. We don't care if that's the real reason that they passed it. None of that matters. Could somebody somewhere with 2 brain cells to rub together think that there was a relation between the law passed and the alleged effect they were going for? If somebody somewhere would believe that, then it's valid. So you can see why the government almost always wins these and the people almost always lose. Example, in 1946 in Illinois, they passed a law saying women could be bartenders only if their husband or their father owned the bar. The reason? We want to protect women from the assaults by men, drunken men in the bar. And if they know that the father or the husband owns the bar, they know they're going to get a sock in the face and they won't do it. That same bar and other bars in Illinois had women waitresses who went out into the bar and delivered the drinks to the drunken dudes. Who is going to get assaulted by those drunken dudes? It's going to be the waitresses who are going out and delivering the drinks to the people at the tables. The bartender standing behind the long wooden bar that gives you, a foot or two between you and the person, that's not the person who's going to be assaulted. It's the woman out on the floor. So what is the rationale? The rationale was to protect the woman. The court actually said it may not be the true reason. It may not result in the effect that they claim they want, but it is possible that somebody could have thought there was a rationale, a relationship between the passage of the bill and the result sought. Now, we all know this is BS, and that was argued in the case. The real reason was to preserve the high-paying jobs, the bartender jobs for men. And that was said flat out, but it didn't matter as long as there was some possible scintilla of thought somewhere that there was a rational relation here. We're going to keep it in. So it did. All right. That's the lowest one. You don't want that. Next one, and next level of scrutiny is intermediate scrutiny. It was created in 1963 in Craig versus Bourne. And it's primarily women. It's almost exclusively women. Other groups have used it in some cases and actually prevailed, disability groups and LGBT groups, but mostly it's for women. And in that situation, the test is you have to have a reason that is true. And you have to have some evidence that it really is going to work for whatever it is that you are trying to do. And the situation was car insurance costing more for, actually this case was the 3.2 beer, that girls could drink 3.2 beer when they were 18, but boys couldn't until they were 21. And the reason is boys drive worse and they're terrible. And, we don't want to give them any beer. So that's why girls, they mature earlier. So we let them drink earlier, blah, blah. So they had to prove that there was some truth to this. And actually, when they did the statistical evidence of insurance, blah, blah, they found it wasn't true, that the boys didn't have any more accidents than the girls did. So they said, well, prove to me that the reason you did this is really going to solve the problem. And it didn't. So they couldn't do it. So this is the intermediate level that you actually have to show that the thing you're trying to do can be accomplished by this, and it is a legitimate state goal. So we started with that, and I was in law school in 76. So we started with that. And the whole women's rights project at the ACLU, which was run by who else? Ruth Bader Ginsburg, right? The point then was to try to keep bringing cases to push this narrative up to where women could get strict scrutiny. That's how they did it in the NAACP cases for Brown versus Board of Education. You kept bringing a case here and a case there and a case here and a case there, and you kept changing the language and adding to it. And it has to be a good reason. It has to be a valid reason. It has to be proven. It has to be not harm anybody, on. And you get adding the language and changing the standards until you get strict scrutiny. So that was the strategy at that time. And that's what women lawyers and women law students were working on and researching and blah, blah, blah. It all came to a screeching halt in 1996. We thought we would get it that way. We failed. In 1996 was the Virginia Military Institute case. And guess who wrote the opinion? Ruth Bader Ginsburg. And in that opinion, she said it was intermediate scrutiny. She added some more tougher language on there, but said women and men are different and women can't get strict scrutiny. We sat there going, what? What just happened? And it took me a long time before I figured out what happened. And what happened was this. I learned it many years later, just a couple of years ago, actually, in reading that book, Women in Sisters-in-Law. And what happened was the decision was 5-4. And she had got herself to write the decision. She wanted to write it, women get strict scrutiny. She couldn't get the fifth vote. one of the justices, and I never found out who it was, said, if you put in strict scrutiny, I'm not going to be on your side. I'm flipping to the other side. Well, then it's 5-4 the wrong way. And they wanted to take women back to rational relation. So she had a really tough decision to make to keep the 5-4 majority, but she had to sell out the idea of ever getting us to strict scrutiny under the legal method. There is only one method left now, and that is the ERA. No cases have been brought challenging this since 1996. It just died right there. All right, so the third level of scrutiny is the strict scrutiny. Now, strict scrutiny means that it's a very high burden for the government to leap over. Why are you passing a law that harms this vulnerable group? You have to have a really good reason why you're doing that and show that there couldn't be any other law that would achieve the same result without harming this vulnerable group, etc. So as you see, if you have to meet this standard, then the person usually wins and the government does not. So who are protected classes? Protected classes are race, ethnicity, national origin, religion. Race, ethnicity, national origin, religion. Why? Because they're mentioned in the Constitution. And the harm of all of that, well, we had a brochure out about, we being the ERA task force, we had a little flyer out that said, you want to protect women? Make us a protected class. Right? Makes sense. So the truth of this came in a case called Morrison in 2000. Well, and any of you who read that leaked decision of Alito, he says basically the same thing in there. Women aren't in the Constitution, so you don't have any constitutional rights, even though we do have the 19th saying we can vote, but that's it. That's all you get. You don't get nothing else because originally you were not in the Constitution. Well, that's correct. We were not originally, neither were Blacks. So there we are. Neither were Native Americans for that matter, or poor people. So anyway, that's another talk. So anyway, the case in 2000 was Morrison. And what happened was the Violence Against Women Act passed, and they included in the act a civil rights remedy for women, similar to 1983, which gives a civil rights remedy to Black people if in their town, their county, their state, they won't prosecute the people who are abusing them. The Black person can go to the federal court on a civil rights violation. It's not the same as a criminal accusation, but it's something. It's better than nothing when your state will not protect you. So they put that same kind of structure into the Violence Against Women Act back in 2000. And so Morrison was the first one to test that. So she was raped at her campus and no one would do anything about it. The campus wouldn't, the city wouldn't, the state wouldn't, the county wouldn't, nobody would do anything about it, even though she tried. So she then went to the federal court to file a civil rights action for the failure of everybody to do anything about it. And they threw it out. The Supreme Court threw it out. They said there is no basis in the Constitution to give women this kind of protection because we're not in the Constitution. So this is the importance of having the Equal Rights Amendment, of being in the Constitution. So how will this impact reproductive rights? No one can say for certain right now because the cases haven't happened. And you know, whenever there is a new major law or especially a constitutional amendment, it takes 20, 30, 40 years before everything sorts out and the cases happen and you figure out what's really going to mean in the long term. And of course, it depends on who the judges are, as we've seen that obviously recently. So, but if men can control their fertility, certainly women can. If men can eliminate their ability to have children, certainly women can. We were talking before we started here about women trying to limit their fertility and being told we couldn't because we were supposed to produce because we were white and we were educated and all of that sort of thing. Where at the same time, they're doing, without consent, they're eliminating women of color's ability to reproduce, but not white women. So all of that, if men can get healthcare as they choose for their reproductive issues, women can too. So there's also a little known case in Arizona, and I say little known because nobody ever I talked to knows about it. It's called SIMIT, SIMIT versus Access, Arizona Healthcare Cost Containment System. It's dated from 2002. And what it was Access said, we are not going to pay for medically necessary abortions. So they took that up to the Arizona Supreme Court. Now, remember 2002, there was no ERA, and Arizona does not have an ERA. But this went in 2002 to the Arizona Supreme Court, and the Supreme Court said, if you are going to pay access, if you are going to pay for medically necessary procedures in every other situation, you are going to pay for medically procedures for this abortion as well. You can't say, I'll pay for all medically necessary procedures and then throw out one just because you don't like it. That's not the way it works. So you have to pay for it. I just saw a report a couple of days ago that in 2020, Arizona actually paid for 2 such abortions. So it's not like we're paying for a huge number of abortions for poor women or anything, but we are because of that ruling back in 2002, which most people don't seem to know about. All right. So with the leak of the Dobbs decision, new arguments have been brought forth. And I have to say that the First Amendment argument has been coming forward, which some of us have been urging the abortion attorneys to use for a while, and they have not. And now we think we were right. They should have been using them all this time. But anyway, a rabbi in Florida has sued because that decision, that life begins at conception, is the belief of one church, only one church. None of the other churches believe it. And some of the other churches have seriously different opinions on when life begins. And so adopting one church's belief as a national law means other people of other religions cannot exercise their freedom of religion because they're following the law of a church they don't belong to. So that's one issue. The other issue is free speech. We have, and they're passed in Arizona actually, but in other places too, there are laws saying, well, you can't tell them certain things, you can't give certain information, blah, blah, blah. Well, if protesters can stand out in front of clinics and scream lies, certainly we can tell the truth. If people at fake pregnancy crisis centers can give false information, certainly we can give true information. These are First Amendment issues that should have been litigated a long time ago. And one of the big things, some laws, including Oklahoma and some other places, I think Utah, have passed laws saying, and even Arizona's law says that, you cannot aid or abet by donating money or raising money for an abortion. Well, excuse me, didn't Citizens United say that money is speech? Money is speech. Well, if money is speech, my speech is to give that money to a woman who needs an abortion. And I have free speech too, just like General Motors. So many of these arguments will be things that you see. And now I just want to take a few seconds to run over some misinformation that has been spreading around about Arizona. What the heck is the state of the law? Until we hear what the decision is from the Supreme Court, Roe v. Wade is in effect, abortion is legal, just as it was before. However, this session, the one we're in right now, Ducey signed a bill, SB 1164, that limits abortion to 15 weeks. That law does not go into effect until 90 days after the end of the session. Now, the session has not ended, so it does not go into effect till 90 days after. There will be a lawsuit against that bill, but you have to wait and see what the heck Dobbs is going to say so you know how to frame your lawsuit and all of that sort of thing. But that is not in effect, so do not worry about that. Now, we have those 2 old criminal laws that we've tried to get rid of for decades and failed. Both of those are under injunction from March of 1973. There was an injunction issued by the court against those when Roe v. Wade passed. They're under injunction. So just because Roe v. Wade goes away does not lift the injunction. They are still under injunction. So they are not in effect. Secondly, we have 2 other laws, one that is blocked completely by an injunction since 2014, that is the 20-week ban. remember back, we used to have 20-week and that got banned, that got enjoined. So that's not in effect. The other one is what just passed last session, adding as a reason to not give an abortion is the genetic condition. Now, I'm a plaintiff in that suit, and that has also been enjoined by the Ninth Circuit. We lost on the race issue a couple of years ago, and the sex one was not litigated. So the only one that's enjoined is the genetic issue, but that's on injunction from the Ninth Circuit as well, with the argument coming up. The two laws that are in effect are both things that never happen, like partial birth abortions and delivering a viable fetus. Those things don't happen anyway, but they have a law against it. And then one law is in effect, but it's at the Ninth Circuit, but it's not enjoined. And that's the one that we passed back in 21, saying that we have to consider all of our laws in the benefit of a zygote, except for IV fertilization. Remember when we had that big about that, oh my God, if you prohibit this, then that means I can't get, IV fertilization. So anyway, it's to do with that. It's at the Ninth Circuit, but it is not enjoined. So it is in effect, okay? So that's just a real short rundown of the criminal area, and I'm sure that Kris Mayes will be talking more about all of that kind of stuff. So that's the end of my presentation. Thank you very much.
Dianne, thank you. That was amazing. That's a lot of information, and there's almost a little bit of hope in there. So I feel good about that. Just one quick question before I go on to Kris. Can you give me those bills that we need to reach out to our legislators about that you gave when you first started? The HB.
I'll put them in the chat. I'll put them in the chat.
That's awesome. All right, great. Okay, so thanks everybody. We appreciate everybody that's just come in the last few minutes. I will let you know that there will be a recording of this salon that will be up on the DGT website. So if you missed anything from Dianne, you will be able to hear it there. Next, I would like to introduce Kris Mayes. She is the candidate for running for the Arizona Attorney General's office. We're very happy to have her here with us today. Worked with her campaign, and so we're glad she was able to come. And as y'all know, the Attorney General's office has a lot to say about laws, and we're hoping that she can continue with what Dianne was telling us about and letting us know where we are here, where we're going forward. So Kris, thank you so much for being here, and you've got the floor.
Thank you, Christine. It's great to be with you. Dianne did a great job of running down the law as usual. I am Kris Mayes. I'm your Democratic nominee for Attorney General. And I think what Dianne just presented, really highlights how important this race is, and quite frankly, how important county attorney races are going forward, and how important they're going to be in the coming years. But I have made protecting reproductive rights and protecting access to abortion even after Roe falls, and I think we believe that it is going to, a top issue in my campaign. I will continue to do that, and I will continue to fight for it when I'm Attorney General. This is a historic night, a very interesting night, obviously, for us to be meeting about this, given the fact that this decision very well could come down within hours. It's either going to happen tomorrow or possibly on Monday. A lot of people think that it's going to happen tomorrow. And in my conversations with doctors, and I'm so glad to hear we have a doctor who's going to speak after me, but in my conversations with doctors and with women throughout our state, as I've campaigned throughout the state, so many people are so very worried about what our world is going to look like when Roe falls. And, I've, spoken with doctors who don't know whether it will be legal for them to prescribe Plan B, to provide an abortion. I've spoken to women who don't know whether clinics will be open or be providing access to abortion. women who don't know whether or not they're going to have to flee to Nevada or California or Colorado or New Mexico for reproductive care. Doctors who don't even know whether they are going to be permitted to have conversations with their patients, right? Given the uncertainty in the law. And Dianne is right that the injunction is in place, but I think that we all would have to assume that someone like Kathy Herod or others will immediately, including probably Mark Brnovich, the current Attorney General, will immediately seek to have that injunction withdrawn, right? So we also know that the Republicans are squabbling amongst themselves about which law will go into, which anti-abortion law will go into place. You know, the most extreme of them, like Nancy Bartow, are saying that the total ban will go into place, right? And then you have Doug Ducey, who's arguing, I think, that the 15-week ban, which is extreme, let's be clear, it's extreme in its own way. It has no exceptions for rape or incest, none. So they're all extreme, and they're fighting amongst themselves about which extreme anti-abortion law is going to go into place. And so, you know, we are looking at a situation come tomorrow morning or Monday morning of great uncertainty in our state. And it is a place that I know you all agree with me. It's hard to believe. It's frankly hard to believe, but it's not hopeless. And that is why I would argue that my race for Attorney General may very well be one of the most important races you vote on, because there are things that I will do as Attorney General to protect reproductive rights, and things that I can do. And here's why. So first of all, I have said before, I've told you this before, and it continues to be my position: we will not prosecute any women or doctors or nurses or pharmacists or doulas or midwives or any medical professional engaged in providing an abortion or receiving an abortion or reproductive care. Why can I say that? And in addition to that, I will utilize my supervisory authority with county attorneys to advise them that it would be unconstitutional for them to prosecute a woman or a doctor or any medical professional engaged in providing reproductive services. And that is because Arizona has an express right to privacy in the Constitution. It's Article 2, Section 8, which I believe means that the laws that have been passed by the legislature are unconstitutional. And it will be my duty as the Attorney General of Arizona to uphold the highest law of our state. So, you know, what we think is going to happen tomorrow or Monday is that the Supreme Court is going to overturn Roe and say that there's no federal constitutionally protected right to abortion. But then they're going to kick it back to the states. And as Dianne pointed out, we have these laws on the books, these trigger laws, and the law that they just passed. But it's my view that because of Arizona's extremely strong privacy language, which, by the way, was crafted in 1912 during the progressive era of this country, we had some very progressive founding fathers, both Democrats and progressive Republicans, crafting that language. And I want to read you that privacy language. And by the way, Dianne, thank you for your arguments about the First Amendment. Those are quite, I think, legitimate as well. But I want to read you the privacy language in our Constitution. It states, "No person shall be disturbed in his private affairs." Let's just pause on that for a moment. Private affairs. What could be more private than what we do with our bodies, right? Or his home invaded without authority of law. So that is our privacy language in the Constitution. And that is what I'm going to rely on. Now, obviously, the Arizona Supreme Court is going to, at some point, be called upon to determine whether my view of that language is correct or not. But for as long as I am serving in office and until they make a determination, that would be my view. I also think that we are going to have a ballot initiative, whether it's whether the one that's out there right now passes or we have one in 2024, but we will have a ballot initiative to enshrine the right to reproductive care. And I think it'll overwhelmingly pass in Arizona. I really do. Arizona is a overwhelmingly pro-choice state. This state, whether it's Republicans, Democrats, or independents, we are overwhelmingly in favor of privacy, and we are overwhelmingly opposed to government intervention in this most private of spheres, this most private of healthcare decisions. And so I believe that constitutional amendment will pass. It will happen. It will pass. But in the meantime, we need prosecutors who are going to protect women from these incursions into their privacy. I want to talk about a few other things. I just released a 12-point plan, and that is it's up on Twitter and Facebook. Will be up on my website soon, but I released a 12-point plan to protect reproductive care in Arizona. Just talked about the first tenet of that plan, the first two tenets. The third thing I want to tell you about, there are states now that are talking about trying to extradite women who go to another state for an abortion. I know it sounds insane. It is insane. But that is what's happening in some of these other with extreme Republicans in other states. And I will never, as Attorney General, participate in any extradition of a woman to another state for an abortion-related prosecution, or any Arizonan. I will never extradite any Arizonan back to Arizona for an abortion-related prosecution. And so you can count on that not happening. The next thing I think that we need to think about is digital reproductive digital data privacy. Not something I think that's gotten much attention, but as Attorney General, I will provide comprehensive guidance to Arizonans about their need to keep their digital data private when they're visiting an abortion facility, when they're visiting an IVF facility, when they're visiting a pharmacy to get a contraception or to get Plan B. Things such as turning off cellular tracking device services, so that governments cannot get that data, and private parties that would harass women cannot get access to that data. I will also fight to prevent internet service companies and apps from gathering that data and providing it to any government entity or any private entity without the express consent of the individual. So these are the kinds of these are the kinds of things we've got to think about. We never thought that we would have to think about these things, right? But we got to think about them, and I think that really needs to start tomorrow. Really, it really needs to start tomorrow in Arizona, given the uncertainty around the law. I will fight subpoenas that are issued, and I'll fight in court to quash subpoenas that are issued to doctors, nurses, physicians assistants, pharmacists, midwives, doulas, women related to reproductive services in order to protect their privacy as well. I also plan to establish a crisis legal hotline inside the Attorney General's office so that we can advise women and families who are the subject of legal harassment by law enforcement agencies seeking to prosecute them, and provide information about their digital privacy, and also provide information about nonprofits that are assisting women in counties where access to reproductive care and abortion is being disrupted. I also plan to convene a working group of state legal leaders on reproductive rights, including my office and county attorneys and other state leaders like mayors to discuss legal issues surrounding reproductive care and the status of our efforts to prevent prosecutions and to protect reproductive care. I will also convene a working group of medical and reproductive care service providers around these same issues. 10th, I plan to work with surrounding county attorneys and governors, including in California, Nevada, New Mexico, and Colorado, in order to attempt to assure the safe passage of women to those states if they choose to seek an abortion or reproductive care in those states. Where I'm worried about harassment of women. I'm worried about down the road, depending on what laws our legislature passes, potential, illegal, I would say illegal interrogations. And so I would work with surrounding states to make sure that women make it to those states if they choose to go there. I will also work with pro-choice attorneys general in other states, joining in actions before federal courts to halt the criminalization of abortion. And of course, I would support a constitutional amendment. So that's my 12-point plan, and just so much to think about. And again, I really can't emphasize enough how important some of these statewide offices are: governor, attorney general, county attorney. What is your county attorney? Pima County attorney obviously has already said that she will not prosecute. I believe the county attorney of Coconino County has said the same thing. That is not the case with the county attorney of Maricopa County. The Maricopa County attorney, in a televised appearance recently, said that she would prosecute under the current state law. She did not answer questions about the pre-existing total bans. So we just don't know. And certainly the folks running for Maricopa County attorney and the folks running against me for attorney general have all said that they would prosecute women and doctors. So the choice is clear, the choice is stark, and we got to fight like hell to make sure that women are protected and Arizonans are protected going forward. So thanks again for allowing me to be with you. It's always a pleasure. It's my joy, and I really am looking forward to continuing this fight with you. I'm happy to fight along with you, I should say. Happy to take any questions that you have.
Okay, great. I was just going to ask you, Kris, if you wanted to take questions now. I know you're on a tight schedule.
I'm happy to, but I'm also looking forward to hearing what the doctor has to say. So I'm open to whatever you want to do.
Okay, well, let's do this just to kind of break it up just a little bit. I believe that Joe has a couple of questions for you in the chat, and then we'll get Dr. Bullock introduced.
Yeah, and a gentle reminder, if you have a question, just go ahead and type it in the chat, and I can ask the question for you. Kris, I think you might have been peeking at the chat because you answered one of the questions very well about. Kris, what if when your attorney general or county attorney does go ahead and prosecute a doctor, a woman, a doula, would you offer office intervention? I think I heard that answer. So thank you for that. Unless you'd like to add anything else.
Yeah, and it's a great question. And I know there are folks on the call who have worked in county attorney's office and offices, and certainly would love their expert opinion on this as well. But look, there is this supervisory authority. It's not well tested. It has not been utilized much. What I would do is certainly first advise that county attorney that what they are doing is unconstitutional. And then if they continue to prosecute, I think we'd have to look at it from there. And I would certainly side with the woman in court going forward. But it's obviously going to be difficult in those states that have these statutes that provide the AG supervisory authority. It is usually enough for the AG to provide that guidance. That usually is enough. But in a case like this, we just don't know.
Okay, okay. I'm going to go back to Dianne. Dianne, you made an interesting point that I hadn't considered before, and that was there's only one religion that has as part of its tenets that life begins at contraception. Obviously, that's not Judaism. You know, you covered that ground. Is it Roman Catholicism?
Correct.
Okay.
But in answer to the other question that was in the chat about nonviolent disobedience and what impact that has.
Yes, yes.
It does have an impact because the whole Constitution and, you know, the Declaration and all that stuff is based on consent of the governed. We can only be either a democracy or even a republic with consent of the governed. We do not consent. And we need to let them know we do not consent. And one of the big things about the Supreme Court is the Supreme Court only has as much power as we give it. If we give belief and adherence to their decisions, and we don't, these recent decisions that are coming out, they're absolutely rogue decisions, and we do not consent and we do not adhere. We will not adhere. And they need to hear that so that they know the damage they are doing to our democracy. So I think we have to show that are not governed. We do not consent to this type of government. So the demonstrations are good.
Well, a great question, Paul, and Dianne, a great answer. That's it for now. So I'll turn it back to Christina.
Great, thanks, Joe. And everybody, get your questions onto the chat so we can get those answered for you from these two great speakers. Now I'd like to introduce Dr. Holly Bullock. She is a obstetrician and gynecologist here in Tucson. She is actually the director resident of research and assistance in the clerkship at the University of Arizona. I think I said that right. She did her training on the East Coast. She did a residency in Hawaii, and we're so glad that she made her way back here to the University of Arizona. Dr. Bullock, if you would like to go ahead and take the floor, tell us a little bit more about your yourself and what your thinking is on the reproductive rights of women and where it stands right now with your patients.
Great. Well, thank you so much for this invitation to come and speak with this group. My perspective is going to be completely different. I am not a legal scholar. I am not running for office. I am just in the trenches, helping our community every day. So from that bio, I'm on faculty. I teach medical students. I teach OBGYN residents. And really just try to help our community every single day. So in listening to our fabulous speakers, I think just starting off with agreeing with some of the things that we had said, but it seems like we all agree abortion is healthcare, necessary healthcare, as is contraception. And then just acknowledging that not all people seeking abortion care or contraceptive services may identify as women. I take care of a lot of trans people and just people with uteruses. So I know that the majority of people seeking this care may identify as women, but let's just remember to even be more holistic with our language so we can be more inclusive. And then the third thing is that abortion bans really affect the most marginalized among us. So that's going to be affecting Black women, brown women, and our community members who may identify as LGBTQ. So really, this is going to impact a lot of people, and we're already starting to see it. I was just thinking, sharing maybe a little bit about my day. I spend time working with Banner, but then one day a week I'm at Planned Parenthood, which is one of two providers of abortion and of course contraceptive services in Tucson. And today I had the great fortune to meet many people and help them end pregnancies that they did not want to continue for a variety of reasons. Also got to counsel people to start their 24-hour waiting period. So for those of you, I know we are a very legally astute group, but there is a 24-hour waiting period in Arizona where someone has to come into our clinic in person. This wasn't even suspended during the COVID pandemic, had to be in person, hearing a rehearsed spiel that was put together to meet the needs of our state legislature. So I go through a litany of all this counseling, and then that starts the 24-hour waiting period. So someone has to come back on a different day, take time off work, find more childcare, and just, you know, every step is a burden to people. And today, you know, we're awaiting this Dobbs decision to come down probably tomorrow. And this was, you know, people were crying because they just know what they need to do, the decision that they are making for themselves and their families, and just not knowing, am I going to be able to get this, you know, tomorrow or this weekend in Phoenix? Or our contingency plan is to help people get to California, where we have our affiliate in Southern California that's going to accept our transfer of records, because of course in California, no requirement of a 24-hour waiting period. And then each, to my understanding, working with colleagues, each clinic that provides abortion care in Arizona kind of has a contingency plan. Some are working with colleagues in Nevada, some in New Mexico, to just help to make sure that we can help these patients get what they need. And so I just also want to take some time and just recognize that things are going to be different than it was before Roe v. Wade, where people were having procedures performed by maybe doctors, that back alley abortion, you know, the evocative coat hanger. Things are different now. 40% of abortions, even now, are medication abortions, and people can get medications outside the healthcare system. They can get them through the mail. People can even get one of the medications just over the counter in Mexico. And so as things change, which we truly anticipate with the leaked draft, that abortion access in half of the country is going to be curtailed, and that'll affect Arizona as well, but that we're going to see people self-managing abortion. And the best data even shows that 7% of people with uteruses, people who identify as women or not, have already self-managed an abortion outside of the healthcare system. And so really, you know, this is safe, and just providing people resources so that they can access this and then know when to seek out help. And so that's what I've been working on in the past couple of months, working with my OBGYN colleagues to train our urgent care colleagues and our emergency department colleagues to know that after an abortion is the same thing as after a miscarriage. People can just tell you that they had a miscarriage. We don't have to document, we don't have to ask invasive questions. We don't have to document it in the legal record, in the electronic medical record, which can be subpoenaed. We want to avoid potential criminalization of our patients. And that's been what I've been working on from that education standpoint and outreach. And so really just working with even our medical students and our residents to just make sure that we are providing the best, safest care, evidence-based, that is not going to further harm our patients. And again, if there's any take-home points from this that I can impart with you, no one could ever tell if someone was having a miscarriage or had self-managed an abortion. There are no tests, there are no blood tests to see if there are metabolites from those medications. Those don't even exist in the research realm, which of course is separate from the clinical realm of what tests can be ordered in an emergency department. So that's a take-home point. And then there is already a wonderful group in our community called the Tucson Abortion Support Collective, that is a mutual aid society that is made up of our community members that are taking care of our community members. And so I know that earlier we talked about, you know, oh, there are laws in the books about aiding and abetting. well, no one's been prosecuted for those. So like if anyone wants to, even just $1 to this group, every time I tell a patient about them, I try to make a little donation. This group helps people with transportation to clinics, helps even with translation services if it's not something that we have on hand. They've even babysat some of my patients' children while my patient went to go get an abortion procedure. They've helped with pregnancy tests, they help with emergency contraception, and they've helped people get out of state. So it's really just a community group that is just gives me a hope and faith every day that there are already kind of these groups in existence, and now is our time to just spread the word so that we can support one such group. So I'm just going to put that in the chat because that's my favorite group to donate to, and I make a donation every month because I know that they help my patients. And so with that, I think I've given you kind of a rundown, a little emotional because we did some crying today because it's just yeah, people are so scared, and they know the decision that they need to make because so many people are mothers already. They have family members and they're truly thinking about those children that they already have when making this decision. So I'll open the floor up to questions and I'll mute myself.
Okay, I do have some questions for you, Dr. Bullock. And what will happen to all women in the first trimester who are having pregnancy complications, or an ectopic pregnancy is the most stringent of Arizona's laws on abortion goes into effect?
Well, like medically, an ectopic pregnancy is a life-threatening condition where a pregnancy is growing outside of the uterus. It's only a pregnancy inside the uterus that can be supported. So an ectopic pregnancy is a need to medically intervene. That is a life-threatening condition. So anytime there is confusion with laws, of course, physicians who maybe don't deal with it every day may get a little flustered. And sometimes I think that our Catholic institutions then tend to just send patients away to non-religious institutions. And so that is a Gestalt feeling that I have. I can't say that they do that any more than they used to, because so much just depends upon where you have 24-hour OBGYN services and surgeons on call. And I don't know necessarily the ins and outs of our Catholic hospitals in town. But that would certainly be, an intervene and save a life. Things, of course, we've seen get dicey in Texas with their ban of any abortion after the cardiac activity is perceived, which roughly is equivalent to somewhere between 6 and 7 weeks. But again, an ectopic pregnancy, that's kind of a slam dunk for need for medical intervention for life-saving purposes.
Okay, how can Arizona prevent Arizona women from having a telehealth conference with an out-of-state doctor and obtaining medication abortion through the U.S. Postal Service?
Yeah.
Is it interstate commerce an issue?
So I will certainly have our wonderful legal people weigh in, but already telehealth abortion in the state of Arizona is not permissible. And even during the COVID-19 pandemic, when many other states relaxed restrictions, and even some of the federal restrictions related to mifepristone, which is one of the medications in medication abortion, was relaxed so that in other states that allowed telehealth abortion, I mentioned I trained in Hawaii, but where you could do a telehealth consultation and then medications be mailed to you. And that was, in unprecedented times, communicable disease pandemic, that laws relaxed. Not so in Arizona. So my understanding is, in having colleagues who do telehealth, you are supposed to, the patient is supposed to be in the state where they are accessing that healthcare. However, in this day and age, I don't really think that you could necessarily, no physicians tracking IP addresses like that. So in theory, you could. However, there are still ways that patients can access these medications outside of the healthcare setting without having to speak with a physician, and that is all through mail as well. So no one's checking the mail to see what medications people are receiving. And that is the way that, say, in Poland, which was very permissive of abortion care in the 80s until they had a regime change, and now abortion is illegal. They have a network similar to like our Tucson Abortion Support Collective that puts people in touch to get medications from other countries, or have consultations with groups outside to get people that medication abortion back to Poland.
Okay, is there a way to stop the fake clinics? And could you name the group again?
Oh, I put it in the chat, and I'll type it out. They are a group of volunteers, Tucson Abortion Support Collective, and they are active on Facebook and social media. And then this is a link to their website.
Okay. Does anyone know if the infamous stadium case signed by former UA President John Schaefer remains in effect? It was an agreement that no abortions can be performed at U of A Medical School in exchange for the football stadium utilization.
Is this going to be over?
Larry?
I know anecdotally it's called the stadium law, but it's not a law. The U of A does not own the hospital anymore. It was sold to Banner Health. They did honor that existing policy in that, and some of this language that I use is their language, not mine, but the only abortion care that happens at that hospital, and my understanding is it's the only hospital in town, is for maternal health purposes. It's not just for reasons like someone not wanting to be pregnant. However, that is a very valid reason for someone not to be pregnant, unless someone has comorbidities, complexities that make it too risky to do an outpatient, say at like Planned Parenthood or one of our independent clinics. Then we have a referral service so that they can get the higher level of care that they need in the hospital. And again, that is proving that they need that level of care, that the pregnancy is jeopardizing their health. So there's no ban, but I have a lot of hoops that I have to jump through to prove that someone needs that care. And it's my privilege to be able to do that paperwork, to provide that care. And it's just part of my job to serve our community, really.
What about preeclampsia early in a pregnancy?
So preeclampsia is a type of disease disorder that we're beginning to understand a little better. That is kind of, as I describe it to patients, this is the easiest way, where the placenta is beginning to release factors into the blood that make the body start to have reactions, almost like an allergic reaction. But one of the serious side effects is labile blood pressures. They can be high, they can be low, and this puts us at risk for various end organ damage. So if someone has preeclampsia early on in a pregnancy, that is a health concern, and she needs to be counseled that her health is in danger. And one option is to end the pregnancy, certainly.
Okay, and there was a really interesting question about all the stuff that you have to read to a patient now. Could you kind of do a rendition of that for us?
Sure. So in order to meet kind of all the laws in Arizona, this is my typical spiel that I tell patients when I meet them, that at this point, this is the last part of your visit today. They've already had an ultrasound. They've already had a pregnancy test. They've already been counseled on their options by one of our healthcare assistants or like a medical assistant, but then it has to be face-to-face consultation with an MD or DO, a physician in Arizona. So I tell them that in the state of Arizona, the state outlines like what constitutes the counseling that we need to do. And that basically that when a person is pregnant, that there are 3 options: continuing a pregnancy and choosing to parent, continuing a pregnancy and choosing adoption, or choosing to end the pregnancy with abortion care. If someone is considering the first 2, I've recommended that they start prenatal care as soon as possible. I then lay out resources on our Planned Parenthood website or on the State Department of Health website where they can have more information. And then I even lay out examples of the types of information about access to insurance. Being pregnant in Arizona can qualify a lot of people for access insurance. I talk about listings of providers taking new patients for prenatal care, where they can find listing of adoption agencies, and that also that there may be private or public groups and organizations that could support them during pregnancy or after the birth of a child. Then I go into abortion care and how no one can force another person to make the decision. That is coercion, that is illegal. Even if a father of a pregnancy has offered to pay for the abortion, if the person who's pregnant wants to be pregnant, that is their decision. Then I talk about the laws in Arizona that can compel a father of a pregnancy to pay child support, and that would start at birth. And then oftentimes I'll do a timeout and say, like, while that is true that there are laws, the enforcement of those laws is absolutely totally different. And we usually acknowledge that because everybody knows someone who is waiting on child support. And then we talk about the pregnancy. We talk about the ultrasound that they had. They should have been offered pictures. Many of them do take pictures. Again, some people just want a memento because this is a choice that they're making, and it can be a hard choice. And it can be, this is just a point where people are making decisions and they can see both ways. So many people are mothers and they know exactly what it would take to have another member in their family. So it's really nice that people, if they need it, they get mementos. That's a really great for helping with closure or decision making. And then we talk about the embryological development that happens would be at the time of their termination if they are choosing to end their pregnancy with abortion. And then we talk about what they've chosen. If they're less than 11 weeks, we can do medication abortion or the in-clinic suction procedure. And we talk about that. And then we go through the risks, benefits, and alternatives. I always have to talk about the risk of death and remind them that the data shows that abortion is very, very safe. In fact, continuing a pregnancy, delivering, and being in the postpartum period, which is up to a year after birth, is a 14 times higher likelihood of death. And then I go through some of those complications that can happen that do increase our risk of death during pregnancy when we live in America. And the very last thing is the latest law. And that is I have to tell people what happens to the remains after the procedure and how we dispose of them. And then should they want to do something else, how they can contact a funeral home or a mortuary service to do something else. And that's been the latest change since September. Other things they already answer, like they have to at least on a piece of paper, write down their reason or check a box as to why they're having their abortion. But it's not anything that I have to ask them about. Oftentimes, then I'll just open up the floor and whatever they need to talk about, it's a time when I just get to be their doctor. I don't have to go through my spiel for the state, and we can just talk about whatever they need, whether it's like understanding their individual health needs or talking about contraception, just whatever they need. And sometimes, like today, it was like providing tissues and just that supportive shoulder, because like things are tough right now. My staff doesn't know if they're gonna be able to come to work. The patients don't know, are they going to have to go to California? It's just such a trying time that's already, a little emotionally fraught anyway. For some people, this decision's really easy, and for some it's not, and that's okay. Humans are complex, our patients are complex, and they can hold multiple emotions and thoughts all at the same time.
Okay, Dianne, if Roe versus Wade is overturned and Congress/Senate codify the right to legal abortion, won't the Supreme Court just overturn that law again?
Well, it's possible that could happen, but in the meantime, time passes. And it takes time to pass the law, and then there'll have to be legal challenges. It has to go through the lower court. It takes several years to get up to the court. In the meantime, the court can change. And there are many actions going on right now to try to change that court and to do things so the court actually changes. And also, when you write the law, you can base it on a different theory, base it on a different right, base it on something else. There's ways that lawyers do to get around that sort of thing. So it's not the same question. It's a different question when it gets up to the Supreme Court after these years, with the interim of attempting to change the Supreme Court to be an actually respectable court that follows the law, as opposed to the rogue nuts we've got now.
Okay. Should a woman stay away from the Catholic hospitals in Tucson? That might be a question for Dianne and for Dr. Bullock. So you have St. Mary's, you have St. Joseph's.
Well, my feeling is yes, that you should. And you should also ask your medical provider, whoever you are, you don't have to be pregnant, just everybody. Ask your medical provider, do they agree with your decision on your end of life decisions, whatever that's going to be? And make sure that if you're at a Catholic hospital, they are not going to follow your end of life decisions if you have something other than, keep me alive at all means. And they also won't follow your abortion decisions or your reproductive care decisions. So I would say, yes, go to a different hospital, but Dr. Bullock might have something else to say.
When you call an ambulance in an emergency, they take you to the nearest hospital. You don't get to pick. So I'm just trying to work with our colleagues there so that we have referral ways. If we need to transport someone across town, we will. But really just trying to build camaraderie, because we all got into medicine to help people. And sometimes it is really tough when you work at a place where the policies may make that harder.
If Roe versus Wade is overturned, Dianne, how quickly would law go into effect?
I don't know, actually, the answer to that. Kris, do you know?
I think Kris dropped off the call.
Has she gone? Okay. I don't actually know the answer to that question.
Okay. And great.
I think most clinics will probably stop until the law, the 15-week abortion ban or the territorial law is decided, and just help people get to legal places and still provide resources so that they can self-manage, because there is no law against that at this point in time.
Well, but that
providing information is still education.
That 15-week ban doesn't go into effect until 90 days after the end of the session. So it's not going to, if the Roe v. Wade is decided tomorrow, that ban is not in effect.
Okay. In the past, a woman could get a psychiatrist to say she needed a termination based on her mental health. Will this still be a reason for maternal health?
Well, I can give you the legal answer, and then Dr. Bullock can give you the other answer, which is that in the SB 1164, which is a 15-week ban, that will be challenged, but isn't, it is not in effect. But it says only medical emergency. There is no exception for the life or health of the mother. They don't care about women. It's only medical emergency. Well, what does that mean? We don't know. Under the legal regime, whenever you use some new term like that, there's several years of cases being litigated before you figure out what that means in terms of the law. So what is a medical emergency? Does that mean health, mental health? Does it only mean physical? Is it the health of the woman? Is it the life of the woman? That is undetermined and will be determined at the cost of women's lives.
Dr. Bullock?
So that seems to be not common reason to pursue. Some hospitals may still have ethics committee where a decision could go if things are ambiguous. And I feel like that's still a vestige of pre-Roe time. And so it may be getting a more robust committee opinion to help decide. It's not a medical emergency that compromises end organ damage that seems to fit the maternal health policies of the majority of academic institutions nationwide that have these restrictions and these restrictive policies in place.
Okay. Dianne, will recognition of the ERA add protection for the LGBTQ community?
The Supreme Court decision in Bostock said that discrimination based on LGBT is sex discrimination. So yes, it's sex discrimination. And if you read the ERA statement at the beginning, what it actually says is you cannot make laws based on sex. So yes, it will cover the LGBT.
Okay, why isn't contraception free so women don't get unwanted pregnancies? Dianne, you want to take that one?
Because we have a terrible legislature. I mean, and we're a capitalist country. And if you can make money, make money. It doesn't matter how many people you harm. So there's no reason except politics. And also a question was asked earlier about the fake clinics. Why can't we stop the fake clinics? Because again, in the United States, you can lie. You can lie, you can tell all the lies you want, as long as you don't quote defame anybody and they sue you, you can go ahead and lie. I mean, we know that. We live in a post-fact world, right? So they can tell all the lies they want and they are able to get along with it, get away with it. Remember years back, we used to have a rule that if you had political ads, they had to have some scintilla of truth in them. Remember that? And they could be thrown off the air or you would be prohibited from that political ad if it was absolutely false. Well, that's not true anymore. That I think we got rid of that in Reagan time. And now you can just say anything you want to. So we can't get rid of them.
So from a medical perspective, just wanting to remind us, no contraception is 100% effective. Even IUDs, intrauterine devices, which are one of the most effective and reversible so that people can have them removed when they're ready to have a child, still have a 1% failure rate. Even vasectomy, which is a permanent contraceptive method, can still fail over time. Same with having, the tubes tied. I shy away from that. It's permanent contraception. It automatically implies someone's tubes could be untied, which is not the case. But like even removal of tubes from a person with a uterus, a woman, still over time has a failure rate. So there are federal programs like Title 10, I want to say, that our county health departments offer contraception for people who otherwise couldn't afford it. And there are other clinics that also can participate in that. And then more famously under the last administration, Planned Parenthood withdrew from that because the caveat was like, oh, we can give you the money for contraception so you can provide it to people, but you're going to have to stop providing abortions. And that was just too big a pill to swallow, of course. So even contraception, not 100% effective.
Okay, well, Christina, we've had a very robust chat room. I want to thank all the participants and back to you.
Okay, great. Yes, thanks everybody that has listened. Dianne, your information on the ERA was amazing. A lot of information that I didn't know gives me a little push to want to get out there and reach out to the Congress and the Senate to get this passed and get it on the books. Appreciate that. Dr. Bullock, thank you so much. Your perspective from the medical side means a lot. And I want to thank Kris. I know she had to drop off. She was juggling a couple of different things this evening. So I'm really glad that she was able to join us and let us know where she stands and how she's ready to help women. A couple of things I just want to let y'all know. This forum this evening is going to be on the DGT website within the next couple of days. Larry Bodine, our president of Democrats of Greater Tucson, works his magic, and we'll get that on the website so you can re-listen to it. And when you're talking to voters, when you're talking to people, just remind them that if the Republicans gain more power, then women are really going to be in a bad place. Let's see, I think I've taken care of everything. Once again, I want to thank Susie Anderson for helping get this together. And thank you to Joe for taking over the chat. Unless there's any other questions, I'm gonna say everybody have a good rest of your evening, and thanks for joining us.
Christina.
Yes, ma'am. Go ahead, Susie.
Hey, well, Jim Hannon asked, how can there be more education on this issue for others? And, you know, Planned Parenthood, I don't know, for young people, it's really hard to get out there. And they are so averse to teaching good sex education in our public schools that, you know, kids are never going to, you know, for the next 10 years at least, be able to learn. So we need to work for our public schools, you know, in our homes, every place we can. So I thank you for such a great question, Jim. I appreciate that.
All right, great. So if there's nothing else, I'm gonna go ahead and end the meeting, or Larry's gonna end the meeting. And thank you, Dianne. Thank you, Dr. Bullock. Thanks, everybody. Have a great evening. We'll catch you Monday on Zoom with the DGT. Thanks.